the operational complexities of free exercise and the adoption of religion clauses in the Nigerian Constitution.
I hope my 20 minutes is not running already. Mr. Chairman, good morning.
A bit less.
Brothers and sisters. The paper is a joint paper between Professor Isaac Oloyede, myself, and Hussein Taye Oloyede. Essentially, we are looking at the implementations of the religion clauses and free exercise clauses in the Constitution. Is it the problem with the provision or the implementation? And our conclusion is that the problem essentially is that of implementation and not provision. Notwithstanding the fact that the provisions are not essentially conclusively adequate. The outline of the paper is as stated. We want to introduce the paper, do a conceptual analysis, identify the dynamics and matrix between state and religion. We also want to dovetail into what operates in Nigeria specifically between state law and religion. Then we want to look at a few of court pronouncements. Then which category can we place Nigeria in the matrix, because schematization of about 10 points have been identified, and of course we end up with our recommendations and conclusion. We call attention to the fact that a look at our section 10, which calls for the state shall not adopt any religion as that of the state. Two parallels. One, some believe is a non-adoption clause, some believe is an adoption clause. Those that believe there is an adoption clause come from the perspective of the fact that whether we like it or not, we cannot devoid a state of religion, because the citizens of the states are adherents of different faith systems, and therefore it cannot be a non-adoption. The adoption position is, and the non-adoption says no. What the constitution is saying is, don't say the state will support religion A or religion B, whichever divide that we belong. What is important is that there is a provision that calls attention to the multi-religious dispensation of the state. Equally interesting is the argument between secularism and multi-religiosity. Secularism is what some people believe Section 10 has provided for us in Nigeria, while some people believe no. If you look at the context within which Section 10 was provided, you will agree that it is essentially a multi-religious clause. And the argument of the secularist is that secularism is about open, don't adopt a religion, while those that believe is a multi-religious argue from that same perspective that no, when we're talking about secularism, some conceptual analysis is to the effect that you should not even talk about religion at all. So if you are not going to talk about religion, Section 10 cannot be the basis for that kind of conclusion. And of course, some people, also the multi-religious proponents, position of Section 10, believes that whether we like it or not, if the legislative body is enjoined by the same constitution to make law for peace, order and good governance, then we cannot be talking about a secular state, because the basis of laws that will ensure peace, the basis of law that will ensure order, the basis of law that will ensure good governance could be found in religion. But whether we like it or not, we have come to a finding that the line between adoption and practice is very, very thin. What we need to do is to create a balance between the governed and the governed. Some of the conceptual issues which I will not bore us with is the concept of religion or religions, depending on which perspective you want to actually look at it. Our concern, as far as this paper is based, is that what we mean by religion is just free practice of one's faith without any form of inhibition. And that if we talk about free exercise, what is important is not liberty. Because if you are talking about liberty, you are likely to come to a situation where there won't be any control. And if there is no control, then there's a problem. So free exercise is implementing or exhibiting your religious faith practices within a confinement, that is a freedom to roam in a cage, as it were. And that we also discover that talking about free exercise, the problem in multi-plural society, in a pluralistic society essentially, is bottom top instead of top bottom instead of bottom top. So we usually look at the political legal approach instead of social cultural approach. The citizen should hold that freedom. That is the only way that the free exercise will work. Then we also did a sort of conceptual or theoretical argumentation on the dynamics of freedom of religion and right to religion. And we say that what we should be advocating for is right to religion and not necessarily freedom of religion. And questioned the present position of the Constitution of Nigeria 1999 as amended with regards to freedom of thought, conscience and religion as being grossly inadequate. That the focus should actually be, if we really want a freedom of religion as it should be a freedom of religion and not lumped with freedom of thought, conscience and religion. We believe that Nigeria still needs to go a bit further to actually donate to the citizens that freedom. And of course, our argument is situated within the ex judem generis principle. That is, this special mention of one means the exclusion of the other. If religion is lumped with those ones, then it means that freedom of religion does not have an independent existence, and that's what we call the ostrich theory, which we believe cannot work. The dynamics of state and religion is essentially from what Durham's perspective appears to be talking about, and that is benchmarking between theocracy and secularism. Durham identified four perspectives of substantive, functional, analogical, and differential. We say that all these things are just nomenclature. All these things are just identification, name calling. By the time you look at them in real practical terms, you will come to the appreciation of the fact that they are essentially synonyms, which on the whole may not create the kind of dynamics or relationship that we expect from them. And we call attention to the fact that law and religion is better examined as more of arts than science. Because if you look at religion, the relationship between law and religion from the scientific perspective, you'll be talking about experimentation, you'll be talking about specialization, which essentially will mean 1 + 1 is 2. That's not what religion is. It's an emotional thing, and therefore it has to be studied from the perspective of the heart rather than science. In looking at the dynamics of law and religion from the perspective of Nigeria, we say Nigeria is an mix of multi-religiosity and secularism. That is, we cannot run away completely, totally from the fact that for as long as we have the situation, the way we have it constitutionally, then we need to look at our position more closely. And that law and religion conflict also need to be redefined, because there is this confusion as if law determines religion, because that is essentially what is happening now, whereas law and religion are only tools for regulating the state. And what is that medium? And that is the court system. What we have today, as far as the relationship between law and religion, is the positions of the separatists and the positions of the harmonists. John Locke and John Rawls champions the separatism position. That is, you cannot separate religion and the state. And the harmonists believe that no, why we are not calling for a separation. I mean, you cannot divide the state of the religion if you really want an harmonious existence in the state. In our view, we believe that those two extremes do not, in practical terms, have any place. What we need is the mid of the road approach between the two extremes. You cannot say state and religion must coexist. You cannot say religion and wow. Well, as far as Nigeria is concerned, we have called attention to those issues, but essentially Section 38 of the Constitution is the primary right, while some other secondary rights are there. Well, of course, the courts are pronounced in various cases, which we identified in this presentation. We also call attention to the schematization by Durham and Scout and Oloyede's position with regards to the fact that no, all these 10 are not, as far as Nigeria is concerned, are applicable. He identified a mixture of 4 of those. And what's our recommendation? We talked about implementation mechanisms of freedom of religion provisions to be improved upon. We call attention to the fact that citizens must make conscious and concerted efforts to hold the freedom of religion. 3, we also believe that independent and distinct legislation for freedom of religion as against the present regime should be in place. 4, we believe that there is need for judicial activism as a way to rescue the free exercise of the clauses. The government and the government must collectively work to ensure the availability and workability of free exercise of faith by all adherents. Thank you for listening.
Thank you very much.